Hello, all. We are on Unit 4, which is property law. And property law will be covered in 4 different chapters. Property law is classified by personal property or real property. And personal property can be both tangible or it could be intangible. And so tangible is what you can feel, you can touch. You're thinking about things like cars, clothing, animals, furniture. Intangible property are going to be things like stocks and bonds, intellectual property, which will be covered in one of your chapters. And that covers things such as patent, copyrights, trademarks, things of that nature. Real property is going to be the earth and things that are permanently attached to it. That is what we consider real property. So it's a little bit different than real estate because real property actually encompasses the trees and things, anything permanently attached to the land. We also have fixtures, and fixtures are basically items permanently attached to the land, a home or building, and they once were personal property, but they became so affixed that they become part of the real estate. And they are considered the property of the land, home, or building. And I shouldn't say real estate, I should say the real property. A commercial building on a foundation constructed on raw land would be something that we may consider a fixture if it was if it was just added to the foundation. Electric wiring or the plumbing installed in the building. And these could also be, may not be, but trade fixtures. And the difference between trade fixtures and commercial or in regular fixtures or personal property of a tenant is a trade fixture if the tenant installed it to help them conduct their business, okay? And so it's sometimes then considered the tenant's property more often than not, and it's not the landlord's property, even if it was attached to the building, okay? But what you would have to do probably if you wanted to take that away is pay for any damages. And these things can include things like machinery installed to manufacture a specific product, or like if you have a coffee shop, all of their trade fixtures are kind of now become affixed to the real property, but that's going to be the property of the tenant. Could be electric panels that were installed to power the tenant's machinery. This isn't improvements. This is trade fixtures, are fixtures that the tenant needs specifically for their business. So let's talk about the nature of property. Basically, when we talk about property law, we're talking about what we call a bundle of rights, and it's what can we do if we have property. There's certain times we can only possess property. Sometimes we control, enjoy. We have the right to exclude or dispose of it. It just depends on our interest in that property, what rights we have. So you can own it, or you can also exercise dominion over something that's owned or possessed, which give you some of these other rights. Property ownership is basically a bundle of rights that allows us to enforce and recognize rights such as use, transfer, destruction, things like that. We are also going to talk about leasing. There is a landlord tenant chapter as well. And basically it's a personal property because it's not a transfer of ownership. So it's a form of a transfer of a right to possess and use personal property belonging to another, but you could also lease real property as well. Ways to acquire property. Well, if you guys sat back and thought about all the different ways you can acquire property, I bet you could come up with a lot of them. Production, probably the biggest way is to purchase property. Unknown property, meaning if there are wild animals, it's the first to claim the animal, or let's say wild, even plants, okay? Abandoned property, if you can show that there was an intent to abandon and you receive that property. That's a way for you to receive ownership interest. A will, gifts, which we're going to talk about a little bit more in detail. Confusion. Okay, what confusion is when you have goods, fungible goods, and they somehow are put together with someone else's fungible goods, but you don't know which one's which. So let's say we have a grain silo. My grain goes in, it's the same type and grade as someone else's grain. I may end up owning that other person's little actual grains, but the weight is what I'm taking out of silos. So I can own ownership over somebody else's grain, even though it's not my specific grain. Okay. Think about money is fungible, right? So I could own a bunch of dollars, but I don't have a specific ownership on a dollar bill per se. I know it's a little confusion. You like that? Anyway, accession. Accession is where someone improves the property, and the property then still belongs to the rightful owner, but that property owner may have to pay for the improvements. For example, when you go and take your car in and someone makes repairs it or puts a new motor in, that's called a cession. You still own your vehicle. They don't get any interest in your vehicle. Although if you don't pay, they can put a mechanic's lien, but technically the only interest they would have is if you don't pay for what you owe them. And that's an improvement that's made to your property, and you get to take that property or that improvement with your property. So I want to talk briefly about gifts. Gifts is a voluntary transfer of property. We have our donee, which is the receiving end, and our donor, which is the giving end. And remember, this is what distinguishes a gift from a contract, the fact that it does not have consideration. The three elements you need is an intent by the donor, a acceptance by the donee, and a delivery by the donor. So as soon as you have all three of those, that gift or that piece of property is now owned by the donee and can't be taken back. So it's all the ownership interest transfers if you meet those elements. So you can also have the delivery be constructive, meaning you can give someone a key to a car or a house, and that would be considered, if you can prove the intent and the acceptance, that would be sufficient for a gift. There are two types of gifts, inter vivos and causa mortis. Inter vivos is living gifts that you give to someone. I want to give you my soda. You say, I would love to accept that, and I deliver it. That's a gift. However, causa mortis is in contemplation of death. Basically, these are deathbed gifts where someone has imminent fear of death, and so they then say, I would like to give you X. And they don't have to necessarily deliver it because it's a causa mortis, because they don't get it unless and until you die. It automatically revokes if the person the peril or sickness that they were under fear of is gone, like they recover from it, or they revoke or withdraw the gift before death, or if the donee dies before the donor, which is interesting because that means, let's say you are having a heart attack and you on the way out the door say, I want you to have my car. I love you so much. I want you to have my car. And you go on the way to see me. I guess I'm saying that to you. Sorry. I say, I want you to have my car. You go to the hospital to see me, but you get in a car accident and you die. The gift is revoked. And the importance of that is that then, since it never got transferred ownership to you, it doesn't go to your heirs. It would remain with my heirs. So let's talk about engagement. There was Lind proposed and broke off the engagement after that. So she gave back the ring. He proposed again and gave her the ring again, but he broke it off again. And this time she said, I'm not giving you your ring back. The court in that case said, this engagement ring is an implied condition of marriage. In order to vest title, meaning in order for you to get ownership, even though the ring was delivered, it's a conditional gift. And therefore, if you don't meet the condition, you don't really have ownership. And this case, the appellee tried to say, well, it was his fault. He broke it up multiple times, but the court said, listen, under no fault principles, the appellant's entitled to the ring. It doesn't matter who broke the engagement off. It's a conditional gift, and if a person conditions a gift by requiring the donee comply with certain rules, it's not a completed gift. Now, Kansas follows the engagement ring rule. However, Kansas does not acknowledge conditional gifts in other areas. So it's one area that they have made an exception, but they say it's conditional. You got to give it back if you don't get married. So the condition of this lecture is that you answer the next question. So I would turn, if you want, to go through and pause as you go through. The first one is question 1 here. Then we have question 2, question 3, question 4, and question 5. Oh, another one, question 6. All right. Now we're going to talk about bailments. You all have entered many bailments and you probably didn't even know it. If you have ever rented a library or borrowed a book from someone, watched someone's dog, or had someone watch your dog or animal, if you've ever valet parked or stored your stuff in a storage building, these are all forms of bailments. Bailment basically is a person has property and they hold the right to possess it. They don't even have to own it, but they have a right to possess it themselves. And so what they do is they give it to someone else and give it to them exclusively for them to have possession and control over it. And then that person's the bailee. That bailee accepts the property, understanding they have a duty to return the property and to dispose of it as directed by the bailor. So why do we have these things called bailments? Okay, well, you create one when you have that right. You give over your property, the bailee accepts it, and they know that you have the duty to do what you tell them to. Okay? So who cares? Well, remember back in our old negligence chapter. Okay? If someone has damaged your property, okay, and they were negligent with it when it was in their control, we have to determine what duty they have to you. So remember, we had duty, breach, causation, harm. We'd say duty, breach, and then it caused harm. Well, what duty does someone have if they're in possession of your property, your personal property, okay? This applies to the personal. And this can be any way you can do it, oral, written, implied, but there's different kinds of bailments. First, if both of you benefit, which is called a mutual benefit. So if I pay to park my car in a parking lot and the parking lot has exclusive control, though, over my vehicle, that would be a mutual benefit bailment. Or if I go to get my car fixed and the only other person besides, actually not the only other person, the only person that has control of it is the mechanic, meaning the mechanic and its employees that basically work as the mechanic, then that would be a bailment of mutual benefit. It has to be exclusive control. I have to relinquish my control and give it to them. So for storage, it would generally have to be if the storage facility was in charge of letting you in and out the storage facility. If there were other people that could have access, or if I even could have access, I haven't relinquished my possession. Okay. A bailment could also only benefit the bailor, the person handing over. Well, how does that happen? Let's say I want you to watch my dog, or I want you to hold something for me, or watch something. That's benefiting me, and it's just for the benefit of me. You're being nice and you're watching over something. Now, it could have the benefit of the bailee. If I let you borrow my car, then I'm really not getting anything out of it, but it's your benefit, and that's called a gratuitous bailment. Why do we care? Well, this is the law has now come down because people start suing when things get damaged, right? And said it depends on what type of bailment, what your duty to that person's property is. If you both benefited from the bailment, is the bailee has to use extraordinary, or I'm sorry, not extra, exercise ordinary, please not extra, exercise ordinary or reasonable care. Okay, so they can't do anything that another reasonable person wouldn't do in their shoes when we're both have this benefit of you having my property. If it only benefits me, the bailor, I give you, you're watching my dog, you're doing something, you would only be responsible for gross negligence, meaning you can't do anything to harm or to really go out of your way to hurt, but you're not going to have to exercise any more caution than that. And if it benefits you as the bailee, then you are going to have the highest degree of care, meaning I'm giving you something to possess of mine for your benefit alone. The law says, you know what? You need to be extra careful. So it kind of makes sense, right? Extra careful if you're basically using someone else's stuff. They give it over to you exclusively to use. Not so careful, not as careful if it's if it's benefiting only the bailor, me. And then reasonable care would be if we both benefit. So it's kind of on this whole spectrum of depending on who's getting the benefit of the bailment. So how do we terminate a bailment? Well, the purpose of the bailment could have ended. I come pick up my dog, you've been watching my dog, thank you. Or you're now taking your car out of the parking lot. It could be at the end of a fixed term. We agreed that I'm going to bail this for a certain time. I'm going to possess this for a certain time. And after that time, it goes back to you. If it's destroyed, if the property gets destroyed, well, there's nothing there to have possession of. So that would obviously terminate it. And if one party gives notice, okay, this only applies to one that's been set for an indefinite period. Okay. So speaking of termination, we are at the end. Question 7 is here. 8 is here. 9 is here. And you're finally on 10. So that in a nutshell is property, personal property. I gave you a little bit of information about real property. You will have a video quiz on easements, so you'll need to be sure to watch that and look for extra credit involving a real estate issue. And that will be it for this week. So good luck.